Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamilton Kerrigan. I've been practicing law here for approximately 38 years in New Hampshire, licensed in New Hampshire, practicing in New Hampshire, and in the Commonwealth of Massachusetts for approximately 28 years. Again, licensed and practice in both states. And during that period of time, I've represented a lot of businesses, and I'm going to be talking today about whether you should put a provision in your contracts about getting attorney's fees. I'm going to talk about how you get attorney's fees in New Hampshire and Massachusetts for that matter, and whether you should put a provision in the contract in regards to it. You first start off with the proposition that while in certain countries, if you have a litigation, the loser pays the attorney's fees of the other side, the winner. In New Hampshire and the United States, that's not the case. That's the American rule is basically both sides pay their own attorney's fees. There's exceptions to that. There's exceptions by statute. By way of example, if you fail to pay an employee wages, then they have to bring a claim. They're generally entitled to get their attorney's fees if they prevail on that. If there's discrimination against the employees, likewise, they're going to get their attorney's fees if they prevail on that. In other disputes where you have certain statutory rights, you might be able to get your attorney's fees. There's something called the Consumer Protection Act, which is a New Hampshire RSA 358A for unfair and deceptive trade practices. So even it applies to businesses and to business. So if you are able to show kind of some rascality of the other side, you're going to get your attorney's fees. But generally for a normal breach of contract claim, absent you putting a contractual provision in it, you don't have that. Now, when you have a loan with the bank gets to get their attorney's fees if they have to come after you as the borrower. Your landlord generally will have a provision in there for your office lease or your facility that you're renting as a business. They'll say that they'll get their attorney's fees, and that will be enforceable too because it's in the contract itself. And one of the things you want to consider when you're dealing with other vendors or your customers in a business, you want to figure out, should I put an attorney fee provision in a contract? And if you do that, you can put in two things. You can say, if we have to collect, then we're going to get our attorney's fees. But usually the other side's going to want to turn that around to saying the prevailing party gets their attorney's fees. So if there's a lawsuit and the court goes and says you win or the other side wins, whoever wins gets to get their attorney's fees from the other side. And I've actually had cases where we went to a trial and both sides kind of won, and the judge went and said in the prevailing fee provision, neither party won and neither gets their attorney's fees, so they just got their damages that they got from the other side. But in these situations, you want to really consider the fact of whether you want a prevailing party attorney fee provision. It doesn't just because you are thinking it makes sense because you don't want to pay your attorney's fees. You want to see what's the risk of going forward with this. By way of example, are you in a situation where you might have a disagreement with your buyer or your vendor or your customer that may be as to the specs, whether you met certain specifications? One thing I will do is I'll try to do what's called limitation of liability provisions in the contract to deal with what the warranties are and everything else. I'll deal with those issues in focus to try to limit the exposure to you. But if you're in a situation and you have to test something, do you want to test it or do you want to be scared of, well, if I test it, I'm not only going to pay my attorney's fees, but I might have to pay the other side's attorney's fees. And the other side's a big Goliath, and it may not matter to them that they have to pay their attorney's fees. Say you have a serious piece of litigation and you have to pay $100,000 in attorney fees to see what the outcome is. If you do that and you lose, paying $100,000 to yourself of your own attorney's fees and then paying $100,000 or maybe more of that to the other side on their attorney's fees, and you lose and you don't get the recovery you want, that might preclude you from actually going forward. You might decide it's not worth me taking the risk. So what I find in what I call Davy and Goliath situation, Goliath might want the prevailing party attorney fee because it's not going to change their life and their business too much if they have to pay on this. But you as Davy, you might not want to. And you also want to be in a situation, if you're in a contract where you could be in a challenge of somebody or they could be challenging you, and you're trying to figure out whether or not you meet the specs of a contract or the like, you may want to be considering whether or not you want to have a prevailing party attorney fee provision, because you can negotiate and say, no, I'm not going to agree to that. I've had situations where I've specifically said to the other side, no, we're not going to agree to an attorney fee switching provision. We're going to stay with the American rule. In that situation, if you're in the American rule, absent some statute like unfair deceptive trade practices, or they also have a common law rule in New Hampshire that says wanton oppressive conduct. And while everyone thinks that they got wanton oppressive conduct, you generally don't. You're not going to get attorney's fees unless somebody's done really something really gross that shocks the conscience of the court. If you don't have an attorney fee provision, if you do that, you're protecting yourself so that you going into the litigation, you're going to have to pay your own attorney, but you're not going to have to pay the other side's attorney. So that's something you want to consider. Again, in other circumstances, when you're really thinking the breach is going to be on the other side, if they're the ones breaching, I want a prevailing party attorney fee provision. I'm Attorney Dan Marr at 603-883-5501, and I'm happy to help you. Again, my telephone number is 603-883-5501. If you're interested in this topic, feel free to give me a call, or if you want to also preview some of my other weekly vlogs, you can go to the website of ours, Nashua Law, go to my bio, nashualaw.com, all one word, and then .com, and then go to my bio, and from there you can get YouTube vlogs. And again, they're weekly and they're all by topic. Happy to help you if the opportunity arises. 603-883-5501. Thank you.